Hello, everybody. My name is Alejandra, and I would like to welcome you to today's Digital Accessibility Liaisons conversation. I'm going to start a slideshow here so that you can see what's going on. So welcome, you're in the right place. That is the wrong date. It should say September, so I will clean that up later. All right, so today's agenda. Um, we are going to do a welcome and any announcements that need to be had. So if you've got any quick announcements, I would take the time now to do this. Otherwise, I'm going to move into my introduction of our speaker. Are there any announcements to be had? I'm not looking at the chat. I see a couple of people posting in the chat. Lots of highs. So everyone say hi. That's a good thing. Lots of highs in the chat. Okay. All right. Since there are no announcements, but that doesn't mean we don't get a chance to make any other announcements later on. Without further ado, I'm going to introduce our speaker. So today's speaker is Dr. Joseph Axel. He is a senior global educator in ASU's Global Launch, where he teaches English to international students. Having worked at Global Launch for the past 14 years, Dr. Axel has been a teacher, trainer, a video developer, a technology reviewer, and for the past 3 years, an accessibility liaison. Thank you. Thank you for being the accessibility liaison that you are. For his PhD in educational policy in 2011, he studied the grassroots efforts of Filipinos in California to maintain the teaching of Tagalog in the public schools. His presentation today is entitled The Historical and Legal Roots of Web Accessibility. In this presentation, Dr. Axel will attempt to create a biographical sketching of the legal lineage connected to the Americans with Disabilities Act of 1990, and that's been amended in 2008, as we all know, in order to understand its roots and the logic and reasoning behind the act and its legal predecessors. In doing so, we will examine one significant human case study and also review two specific Supreme Court decisions leading up to WCAG 2.1 AA compliance mandates. And then we'll have an open Q&A after this. So without further ado, I'm going to stop sharing.
Alejandra, thank you for that introduction. I appreciate that.
Yeah.
I really appreciate the opportunity to talk about this because primarily what this presentation is kind of a self-imposed interdisciplinary study in two new um, avenues or professional skills that I'm developing. And primarily because I've been an English teacher for 25 years. I started out teaching ESL in the Chicago area, and also teaching Spanish bilingual classes in a transitional bilingual program. So I was a linguistic accessibility liaison, if you will. And I came to Arizona where I graduated with my master's in ESL curriculum instruction and a PhD in policy studies. And so in the past 13 years, I've been with Global Launch under Julia Rosen's guidance. We've gone from traditional brick and mortar ESL type of classroom programming to world-class online programs, including MOOCs, massive open online courses. So for the past 13 years at Global Launch, 10 of those years I've been a teacher trainer, and for the past 5 years I've been a technology reviewer, an ed tech reviewer, and a video developer, YouTuber with 800, I think, subscribers. But in the past 3 years, I've transitioned or eased into an accessibility liaison under the guidance of Kathy Marks. And so I would like to thank Kathy Marks because if it weren't for her and for her leadership and her mentorship, I would know really very little, if nothing, about accessibility. I wouldn't like before 2 years ago, I didn't know what WCAG was, World Content Accessibility Guidelines. I probably wouldn't know about the DOJ compliance for 2026. So I would like to say thank you for Kathy for introducing me to this new, really important, big world that was started with like the tech research that I started 5 years ago and blossomed into something really, really super valuable. But also in the past couple of years, I have casually studied law. I am kind of entertaining. I've been an English teacher for 25 years and a teacher trainer. I'm kind of entertaining a career switch where I think being an immigration lawyer would be really an intrinsically rewarding position to have. I think at any time of human history in the U.S., I think it would be great to help people want to come into the country and having smart, savvy lawyers, I think would be really helpful in that avenue. So I'm kind of toying um, uh, with law or studying it anyways. And so this project, the historical and legal roots of accessibility is really my own teaching, my own research project. So I am somewhat of a novice with law, but I'm a little bit more adept at accessibility. I'm now remediating some of our department's curriculum for to meet accessibility compliance. So let's jump into the presentation outline. So in this presentation, in order to really kind of look at the historical and legal lineage of what we know today to be like Americans with Disabilities Act and accessibility and the WCAG standards, is that I'm going to go all the way back to the 14th Amendment, kind of a really not the grassroots, but the ground in which a lot of the grassroots efforts effervesced, and then the laws came to be eventually, like Americans with Disabilities Act and Civil Rights Act, Brown versus Board of Education. And looking at this kind of a familial lineage study and ontological study, like the origins of accessibility. And by the way, this is my own like Simon Sinek type of like, what's the why behind it? And this research study is more for me to inform myself and then sharing it with you. We'll look at Helen Keller as being not just an advocate, but an activist, someone who really had significant leadership within multiple arenas and had political influence as well. We'll look at some early federal acts supporting people with disabilities, kind of like the seeds from which the civil rights eventually sprouted in Americans with Disabilities Act. We'll look at one of the biggest landmark cases as far as like overall desegregation, and that would be Brown versus Board of Education leading up into civil rights. And then we'll look at a couple of legal cases. They're not, let's see, the two legal cases we'll look at are not Supreme Court cases, I think, which is a good thing, because I think a lot of the Civil Rights and Americans with Disabilities Act is allowing like the lower courts to work with and deal with some of the accessibility issues with regards to the law. A few terms that I'd like to put out there as being, I think, significant to the framing of this presentation would be ontology, looking at the roots, what's the behind story, but what are the predecessors that came before, and what are all those extant influences and acts. So in this case, not only is it a historical and legal study, but it's really in the nature of accessibility. What is it? And what are the roots and the origins? And when it comes to liability, we talk about liability in insurance context, but also legal context, and liability is basically responsibility. And throughout the course of me putting this presentation together, my concept of legal liability went from feeling like I was carrying the weight of the world of the DOJ, Department of Justice's mandates for compliance, feeling a little bit of psychological something dissonance maybe, to realizing that looking at the laws, that it's actually the U.S. government, the state governments, and the entities that have a liability. Like the pressure and the responsibility is on the laws that, or the people that proctor our laws or oversee our laws that protect us. And we'll look at the 14th Amendment specifically for that. And then in order to put really a human face on laws, because when you talk about laws, I think there is kind of a nebulous nature to a law. I mean, it's codified, there are numbers, and we know that laws are introduced in the Congress and in the House. You've got the Senate will look at a law, they'll debate it, it'll go to the president, then it'll pass or it'll be vetoed. So there's a process, but before it gets to that point, whether it's debated in Congress, is that there are people behind it, which is why I've got grass in the background, blades of grass. So with that, I'm going to move on to the basically what we're looking at here. If everybody could see like the Russian nesting dolls here. This slide represents my hypothesis. I know it's a visual hypothesis. So my question is, what are the roots? What's really behind WCAG and Americans with Disabilities Act? And so my hypothesis was that I knew that there were layers upon layers upon layers. And my grandmother was born in 1925. She would be 100 years old this year. But so when I was a kid, I played with the Russian nesting dolls, and they were made of wood. And they are fun. They're tactile, but they're also reflective of how when you peel open the big one, there's another one inside and another one inside. And so this was a concept in helping me understand the connections and the influence that like one law will have on another, or one act will have on another, and subsequently and so forth. And the Russian nesting doll, or what's called the Matryoshka effect, which in Russian means the little mother. So it's a way to like conceptualize, visualize the effect of having one be within inside of another. And on the right side of the screen, it says WCAG 2.1 World Content Accessibility Guidelines 2.1, and then ADA and Civil Rights. And this really represents the K part of the KWL chart. KWL meaning what do you know, what do you want to learn, and then what have you learned at the end. And so I challenged myself, what do you know about the legal history of WCAG and the standards that have of compliance, the gold standard, if you will, or double A, WCAG 2.1. And I came up with, okay, well, because of Kathy Marks, I know about WCAG 2.1, which is almost like a dictionary of like how to, from color contrasting to headings. And then I went a little further and I'm like, well, I know about the Americans with Disabilities Act, but 1990, 2008 amended. I wasn't totally sure about the two of them. And then civil rights, that's as far as I got. So in researching this little interdisciplinary project, I learned that there were much more rings to the tree, if you will, that the roots went a lot deeper. This next slide, and all of these pictures were created on Bing Image Creator. And what I started I have alt text for most of the pictures, and most of them start out with like an abstract, colorful picture of. And so to get away from the big kind of like non-personal, impersonal law, codified law, I realized that there were people behind these laws, like reasons for these laws, like Americans with Disabilities Act and Civil Rights Act and Rehabilitation Act. And so in order to like make it more personable, I realized I focus on the grassroots effort, which would be the faces, the real people, and the movements that human beings engaged in collectively in order to have services or to get some rights or to make some changes. That it really starts with people. And so with this picture, I'll describe it. It is a colorful abstract picture with grass, thick, lush, multicolored grass in the foreground, and then colorful, younger sapling trees in the background. And in this picture, it's an analogy to me. The trees are the laws, like Civil Rights and Americans with Disabilities Act, Brown versus Board of Education, that had to come from somewhere. They didn't appear out of the ether, that there had to been some movements of people saying this isn't right or this is what we want. And so in looking at this, it made the research a little bit more personal and gave it more of an intrinsic reason. So the first three, and if you were to have this slide open, you could click on most of the slides that have boldface italics. There will be references in there. So you could click on National Association of the Deaf and it should give you a link because my reference section isn't super thorough, but a lot of the references are on the slides. That the first three, Americans Association of Workers of the Blind, National Federation of the Blind, which are really early precursors of accessibility liaisoning or advocacy, were all had Helen Keller, the person I'm going to talk about in the next slide, had worked with or was a spokesperson, wrote for, advocated, was an activist for all of these associations, except for, I believe, the ARC. The ARC from the 1950s was an institution that was renamed, or organization supporting people with intellectual and developmental disabilities. But these are all people coming together saying this is what we want, and that eventually have the power of the people, true democracy, to make changes for the community. And in my case, in my dissertation with ASU, Mary Lou Fulton was looking at Filipinos and how Filipinos in San Diego and Los Angeles, really in California, fought to have Tagalog taught in the high school level, and they did it. So I do have some experience with grassroots, but not a lot. So let's look at a case study in accessibility. So this is Helen Keller, and on the picture that we have here is a picture of an 83-year-old Helen Keller. Helen was born in 1880. When she was 19 months old, she had a fever, I believe it was scarlet fever, and she lost her ability to see and hear. So she was then deaf and blind. And in this case, deaf blind are two distinct cultures. So we're going to capitalize both of them as their own proper nouns. And so it's a compound noun that's actually a compound proper noun, which is why deaf and blind are both capitalized. So she had a very unique teacher that I'm going to talk about in a second, kind of a Russian nesting doll where one teaches the other, Anne Sullivan. But Helen learned how to sign. She learned how to read and write in Braille. She ended up being the first person, deaf and blind person, to graduate with a bachelor's degree from Harvard's Radcliffe College in Watertown, Massachusetts. And then that was just the beginning of her, like just the springboarding of her activity throughout her life. She eventually won the Presidential Medal of Freedom from Lyndon B. Johnson in 1964 for decades of work for people with disabilities. She advocated for Braille literacy. She promoted access to books for blind readers that the Library of Congress ended up inserting, like one of the biggest databases, right? The Library of Congress before there was an internet. So she was a true advocate. She was a founding person in the Americans for Civil Liberties. And this isn't the only slide I'm going to talk about her about. I'll talk to her about her influence in some of the political arena as well. So here's one definitive face. And why I like this picture is because when I was 8 years old in 1980, I saw the movie The Miracle Worker starring Patty Duke, who's the actress sitting next to Helen Keller. And in this picture, Patty Duke was, I think, 15 or 16, but she was playing an 8-year-old. So in 1980, I'm watching The Miracle Worker as an 8-year-old see this another human being my age struggle to have access to information and communicating with people. And I got to tell you, it's made a lasting impression on me, in the way I look at life and the appreciation I believe that I have for any abilities that I have because of Helen Keller and how she was portrayed in the movie The Miracle Worker. So talking about The Miracle Worker, Helen Keller is the young girl in this picture on the left. And the woman on the right is Anne Sullivan. And Anne Sullivan was coined the Miracle Worker by Samuel Clemens, also known as Mark Twain, because of the work that he did with Helen Keller. And so Helen was an 8-year-old who cannot communicate with the world in a very rudimentary way. And Anne Sullivan came from the Pratt School for the Blind and taught Anne how to communicate. I think there was another movie in 2000, for reference, but she really, and Anne was also visually impaired. She had trachoma, I believe, was an eye disease from a younger age. And so her first teaching job was to work with Helen Keller. Um, and when I think of, again, the Russian nesting dolls, I see two of them here where, Helen Keller looks like she is vulnerable, that we have a liaison who is Anne Sullivan, who's helping Helen to interact and access the world. But then I think in the subsequent slides, hopefully you'll see that too, how Helen Keller really helped to shape how our country viewed itself and applied its laws as well. Moving on to a legal lineage of accessibility, and it is really, I think, a challenge for in a lot of legal cases, especially when it comes to like equal rights and accessibility, to not have some sort of an implication of either direct mention of or an implication of the 14th Amendment. And the 14th Amendment was significant because it was multiple reasons. I would say the primary reason is that it provided an equal protection clause. And so conceptually, I love the term equal protection clause, because for some reason, sometimes I'm locked in the concept of like equal opportunity, but like equal protection places liability, responsibility on government entities like schools to not only provide an opportunity, but to also protect people in the United States. So the 14th Amendment is significant because it came out in a really tumultuous time in the United States right after the Civil War. Civil War ended, well, 1861 to 1865. 13th Amendment abolished slavery. 14th Amendment, 1868, said no one should be deprived of their life, liberty, and pursuit of happiness. But what the 14th Amendment did, two different things for accessibility purposes. It provided equal protection clause, but it also provided congressional enforcement, which gave Congress the right to establish laws that could be enforced by state and local governments. So this is really kind of with the tree analogy, it's the earth. It is the nutrient-rich earth from which the tree of civil rights and Americans with Disabilities Act, with the umbrella of WCAG, has grown over the years. But without the 14th Amendment, I think maybe our country would still be, hopefully not struggling as it is, but it's better because of it. So here we are with Helen Keller again. So this image is from Bing Image Creator. If there is an alt text, I'm not sure if I have one for this, I'll read it. But with Bing, I wrote an oak tree in the middle of a forest, with its roots being shown in multiple, with the American flag imbued into the trunk of it. And so here we have notions of accessibility, but even though the tree is beautiful, it doesn't feel like it's super accessible, like it's in a forest, right? You have to be wandering on the forest. And this would be a kind of analogous to like you having to have some legal knowledge and know-how in order to access that right. Like from the 1868 on until the civil rights, there was decades of people getting their constitutional rights trampled on because they didn't know it, because law is very, very inaccessible in some cases, in a lot of cases. And so in looking at all of these like seedlings, let's say some of the strengthening of the tree, especially in regards to accessibility for disabilities, which is where we are now with WCAG and Americans with Disabilities Act, is that we have a number of different acts that were passed by Congress with the help of Helen Keller. She was often used as requisitioned as a spokesperson, as a prolific writer, not just an advocate, but an activist. She wrote she wrote a letter to Mr. Woodrow Wilson in 1917, right before the 1918 Smith-Sears Veterans Rehabilitation Act was passed. And I read over it, and I didn't see anything that said accessibility or rehabilitation, but what her letter was a kind of a big soliloquy about how the world works. And she was saying that she knew it, and it's the U.S. government runs like a big company, and you have a responsibility to take care of those people, kind of strengthening the 14th Amendment. And she was getting these ideas from people that were disabled that she was working with directly. She visited, I think, 90 army or military hospitals working with soldiers who had been injured in war. Even though World War II hadn't kind of started yet, in 1915, the Permanent Blind War Relief Fund was spearheaded by a man named Kessler, who was on the British ship Lusitania when it was torpedoed by a German underwater boat. But he survived, and then realized that he needed help in helping people that were disabled. And so the same with 1918 Act, the Smith-Sears Act, Vocational Rehabilitation Act of 1901. And 1931, I think, is a really important, all of these are important as they are like watering of the tree and strengthening of it, giving the tree nutrition, which would be, eventually the Civil Rights and Americans with Disabilities Act. The Pratt-Smoot Act, I believe, was really thinking about accessibility today. It's all technological, but you had to have some sort of a early ontological step, and it would be the inclusion of audiobooks and Braille books into the Library of Congress. With the Pratt-Smoot Act of 1931, there were, I think, $100,000 that was allocated to the inclusion of this database of books, and a lot of it had to do with the work of Helen Keller promoting writing letters, speaking to people, and working with organizations. So again, these laws would not be passed just because politicians are in Congress and the Senate, but it's because of people, these grassroots efforts of people like Helen Keller, who to put it in a bare minimum, the activity is like writing letters, communicating with other people, going to see them to make change. So in between, let's say, the 1930s and the 1950s, that this country went through a depression, like the stock market crash in 1929. So I think everybody was fending for themselves in a way during the 1930s. 1940, this country got involved in World War II. But in the 1950s, the social consciousness was growing, where people were, if I were to borrow from Harriet Martineau, who was a feminist from England in I believe it was the 1700s, 1800s, she remarked on what a hypocrisy the United States was, that we had these laws, amendments of life, liberty, and pursuit of happiness, but we had so much segregation and social stratification and all this stuff, that in the 1950s, I think the consciousness of the United States was really ripe for the civil rights, which came in 1964. And if it weren't for Brown versus Board of Education in 1954, I don't know if the civil rights would have been passed in the 60s or maybe in the 1970s. I think it would have happened. But looking at Brown versus Board of Education, this was a landmark case because it overturned a previous Supreme Court decision in 1896 with Plessy versus Ferguson, where the adage of, separate but equal. But going back to the 14th Amendment, where there's an equal protection clause where the government and institutions have a legal liability to protect you if you are a United States citizen. So here we have kind of a hypocrisy where we have a law stating it, but then we've got this de facto kind of thing with segregation. And with Brown versus Board of Education, Linda Brown had a school that was in her neighborhood, but she couldn't go to. I might be, I'm just a succinct history, but I believe, if I remember correctly from reading, lots of different things going on in the case, but there were railroad tracks in between her and the school that she was going to. And so not all kids make the bus. And one of my theories is that one of the reasons that the Brown versus Board of Education, maybe one of the nuances, is that it showed that segregated schools are not constitutional, and that even there was governmental liability in protecting, that it goes beyond the, equal opportunity. What does that mean? But equal protection of one of our citizens. So Brown was huge. And then jumping into the civil rights is where we really get like the roots of the, not the roots of the tree, but where um, the tree is kind of really coming out of the ground and strengthening. It's no longer a sapling, but the civil rights with its specific titles and giving protections to people, that there was a prohibition of discrimination based off race and gender and religion, and that any schools or governmental institutions that provided public access, this would include businesses, any government entity that has federal funding, had these specific titles that were were being were being lined up and used as some sort of a categorical checklist to make sure that that it what Section 5 of the 14th Amendment gave power to the states, constitutional power in order to defend public access to spaces, make it accessible, equal access to federally funded programs. Section 504, which we'll look, I'm going to go back in just a second. I went a little bit too far. We'll go back, civil rights. So after the civil rights, one moment, please. After the civil rights, we had a number of, let's say, measures that strengthened the civil rights. Because what was happening in the United States was that laws like the 14th Amendment were passed, these big amendments, but they weren't being carried through. It's like the Civil War ended, but yet Jim Crow lasted until 1964. But then even after 1964, you have so many different measures, acts that were strengthening that original idea that wasn't really being put into place yet. And so with this picture, we have maybe a little bit more accessible picture than the previous picture of the tree that was in the forest. So in this picture, I placed the same prompt, which was a picture of a very strong tree, an oak tree with a road next to it, in a forest with the United States flag imbued into it, with a soft canopy, with a ground crew watering it. And I wanted to do this because I wanted to conceptualize, now, is this the DOJ? Are these the laws? What's the analogy here of the grounds crew, the person that's watering the tree to protect it and make it flourish. And realistically, this could be whatever you think it is. Sometimes it changes for me. Sometimes I think that this is WCAG. Sometimes I think it's the spirit of Helen Keller watering this idea, this notion, the spirit that's imbued into or embedded into our laws, 14th Amendment and civil rights and Americans with disabilities. But knowing that this is all a process, right? It's not like there's a direct line to creating a law, but not only when you create a law, but when a law is created, oftentimes there needs to be major reinforcement. And so since the civil rights, there have been other acts that have reinforced this idea of equal protections and accessibility for people with disabilities, which is why we're all here with this accessibility meeting. So the Rehabilitation Act of 1973 is something that is probably one of the landmark cases or acts that, I wouldn't say a landmark case, but it's a really salient or important act that strengthened the civil rights. It's like the Russian nesting doll, civil rights, and underneath that is the Rehabilitation Act, and then what comes from that as the Americans with Disabilities Act. But just like the Pratt-Smoot Act of 1931 was first known to incorporate like audiobooks and Braille books into the Library of Congress, that the Rehabilitation Act of 1998, the amended one, is one that specifically stated that required federal agencies to ensure their electronic accessibility, or their electronic information was accessible to people with disabilities. So this is where in law, it's good to be pretty explicit, because otherwise there's a lot of room for interpretation. So going beyond my KWL chart where it's like, I know it's WCAG and then it's ADA and then it's civil rights, I would say that the Rehabilitation Act is a big one to understand, like, from what are some of these legal cases, where are they coming from, and what do they cite? Um, and in a case that we're going to see in just a look at just a second, Robles versus Domino's, that was a case that was initially dismissed by the U.S. District Court in California because it stated Domino stated that it wasn't fully aware of like these accessibility needs, and so Rehabilitation Act, the Individuals with Disabilities Act of 1975 was like another ring in the tree of accessibility, if you will. And then we get the Americans with Disabilities Act, and this is like what I consider to be the trunk of the tree. I think the civil rights were the roots that were coming out of the ground, even though they were fed by um, some of the early acts to help disabled people have access to information, Library of Congress materials. But with the Americans with Disabilities Act, it extended accessibility to employment and public accommodations, um, um, and it's a basis for a lot of lawsuits as well, for arguing why, let's say, a context is not making accommodations or violated some sort of a right. And so the strengthening of the tree, the roots is civil rights, the visible roots, I think, are a mixture of the 14th Amendment and the Civil Rights. And Americans with Disabilities Act, I think, is like really the strong trunk of the tree. It's kind of the visible one, from which all the branches kind of start to branch out. And so this was 1990, and there is a Americans with Disabilities Act amended in 2008, which, if I'm not mistaken, expands coverage of people with disabilities to include cognitive disabilities, and if anything, and just like the Rehabilitation Act in 1973 and amended again in 1988, that laws aren't done cooking sometimes, they're not done growing, that they need support and they need the original grassroots efforts of people to kind of push something new through. And so with the Americans with Disabilities Act, we get five specific titles. Sometimes I confuse the civil rights with the titles with the Americans with Disabilities Act titles. I'm still kind of a work in progress with that. But public services, Title II, government entities, public schools, Title II is what we're adhering to. But also, we at ASU have lots of collaborations with third-party entities, and these are considered public accommodations. And so we at ASU have a couple of different titles that we should adhere to participate in the liability in a good way. I mean, participating in the responsibility of making sure that our content is accessible. And I know that, let's see, what time is it? It's 2:40. We're almost done here. Let's look at a couple of recent lower court legal cases as kind of a case study. So here we have a picture of what's called Justicia, or Lady Justice. Justice is blind, it should be impartial, right? With the scales of justice. This was made on Bing Image Creator as well. On top of a pyramid out in the desert, a colorful abstract image. And this was to illustrate how, this is just a teaching tool for me as well. Because I didn't know that there were 13 U.S. courts of appeals, and I didn't know there were 94 U.S. federal district courts before developing this presentation. So I appreciate the opportunity, Alejandra, to present because it's been a learning tool. But the top of the pyramid is the Supreme Court. The middle is the District Court of Appeals, or the U.S. Courts of Appeals, also known as the circuit courts. And they're called the circuit courts because federal judges back in the day historically would actually go around in a circuit and in the different regions that they managed, and would listen to cases and return home. So, and then the 94 U.S. federal district courts are the trial courts, if you will. People have complaints, civil complaints, and then they debate. There's plaintiff and a defendant. So this is here's the significant part of this is that I initially thought that I would um, maybe see more like Supreme Court decisions based off of accessibility. But what I feel in my preliminary teaching of myself is that it seems like either these cases are being settled out of court after they've um, uh, been uploaded or submitted into the district courts, or the appellate courts, the circuit courts are being able to make these decisions, these constitutionally based decisions, and having them stick and not having them go to the Supreme Court. So what that kind of tells me is that the Americans with Disabilities Act of 2008 and amended in 2008, 1990, and the Civil Rights are really pretty strong in their constitutions. Is that the lower courts handling these, I think, is showing some real success. Now, I may be wrong. I'm kind of early on in my own research and the legal aspects of accessibility, but it's something that I'm starting to see as maybe a trend, which I think is a really good trend. Not to say that there won't be lawsuits, there won't be like litigation, there won't be civil complaints, but if there were to be, like in the two cases that we're going to look at here in a second, hopefully it won't be malicious and it will just be unintentional and it'll be settled out of court, right? So the one of two cases, as we almost end 43 minutes, is that Robles versus Domino's Pizza. And in 2016, Guillermo Robles, Robles means oak, by the way, in Spanish. And so here we have a tree analogy. So, and I just thought about that actually. So Robles is a vision impaired, a blind individual who tried to order pizza on Domino's phone app twice, and he got the wrong pizza both times. And so he filed a complaint with the U.S. District Court, and the district court said that the Domino's Pizza was not liable for or responsible for adherence to or Americans with Disabilities Act could not be applied in this case. However, the court was or the case was appealed in the Ninth Circuit Court, and the the circuit court's like the middle court between the Supreme Court and the district court. And the Ninth District Court stated that yes, Domino's Pizza had to comply with Title III public accommodations of the Americans with Disabilities Act. So here we have Americans with Disabilities Act, but we have subsequent like lawsuits that are helping to strengthen that accessibility or that ethos, right? The spirit of the law itself, because now these become part of case law. And when subsequent, let's say, civil complaints and lawsuits emerge, that there are these cases that show how a public company like Domino's can be liable for public accommodations. And realistically, if you want to, again, 14th Amendment, looking at equal protections, right? Thinking about Brown versus Board of Education, which was a big, huge case, but really it was like an 8-year-old, Linda Brown, who had to walk across a train track in order to get to school while there was a school safety issue, right? When it comes to access, it's like, okay, you couldn't order pizza, but think about people with food allergies. That what if he would have ingested something that could have been harmful to him? I mean, that could have increased the level of liability and damages. So in these cases, these are like hypotheticals, but the case is real, and even though we're not a pizza making, we are an educational entity. So Title II, that it's a subsequent case that shows how web accessibility is important for people and it's necessary. And here's a person who had trouble with accessing, ordering a pizza, something simple that we do sometimes once a week. Some people order stuff on their phone all the time, and imagine how frustrating, real empathy with someone, because laws are supposed to be made for everybody. And when everybody benefits from them, then we benefit selfishly. Okay, so let's see, being cognizant of the time. Um, Here's the process, just like um, uh, civil rights, I think, came from Nesting Doll, Brown versus Board of Education, all of the acts in the 1915, 1918, 1921, 1931, to promote accessibility for people with disabilities. Um, that even even though we have these laws, there's still litigation of these laws. And so Guillermo filed a complaint 2016 and I believe just settled in 2022. So it really shows the slow process of law, just like a tree. A tree doesn't grow overnight. Like bamboo might grow overnight, but the oak tree just takes a long time to grow. And in a case like this, where you would think that it was, well, isn't that clear cut? It's a discrimination. It's not adherence to Public Accommodations Title III. That um, oftentimes the nature of law requires that people discuss it, and it's debated. And maybe even it might take a step back before it takes multiple steps forwards. Like Plessy versus Ferguson was a total step back, from like the 14th Amendment and the end of the Civil War. But the civil rights eventually was like a major step, a huge step forward, multiple steps forward. The last case, and then I know that we're almost out of time, is somewhat of a recent case. And here is kind of the irony is that a lot of our story starts at the Perkins School for the Blind in Massachusetts, where Anne Sullivan went to school and where she was educated to come teach Helen Keller, right? You think about the Perkins School for the Blind being like an outer shell of the Russian nesting doll, and then inside you had the growth of Anne Sullivan, and Anne Sullivan um, taught Helen Keller, and then Helen Keller dispersed as a very prolific, active activist for disability. That We come back to Massachusetts, where another kind of like I don't want to say I'm gonna like a legal indemnity and say that Harvard and Massachusetts Institute of Technology have been pioneers and avant-garde and at the bleeding edge of technology when it comes to online education and massive open online courses. And when you're a leader, sometimes uh, not that you make a mistake, but things emerge that require attention and altering and changes. And so the National Association of the Deaf, or the NAD, along with multiple other grassroots organizations, legal organizations, the ACLU, groups that really are the support of that tree of the civil rights and Americans with disabilities, that filed, I believe, two different class action lawsuits, one against Harvard and one against MIT, specifically for not having like online content and podcasts accessible, especially with I believe closed caption is what it was. But this was 2015, and lamentably sometimes changes are made because of errors. That's wisdom often comes from experience, and experience often comes from failing 14 out of 15 times. And so those cases never made it, if I'm not mistaken, into the second level of our judiciary system. These cases never made it out of the district court of Massachusetts, that they were settled. There was a negotiation, right? True democracy. Let's debate it and talk about it and come to a terms to it like human beings do, instead of getting into like the appellate court where they had to appeal and so on and so forth. So I think these are good things. Like Harvard and MIT probably, I don't know, they probably just realize that it's a part of the evolution of the world going online and accessing phones to access their courses and all the materials and so on and so forth. And so that is really the last case. They both weren't Supreme Court cases, but they were cases involving a lack of accessibility and what happens. Where some of the the debating that goes on and some of the decisions that actually are brought forth with the district courts or the appellate courts, but not the Supreme Court, as we'll undoubtedly see Supreme Court decision based on accessibility in the future, especially with the mandates of WCAG 2.1, triple A or double A, called the gold standard. After that, let's say statute of limitations or a compliance date of April 26th, that probably in the next 5 years, I would guess, right? Looking at the history of laws and acts and how subsequently there are other laws or lawsuits that emerge to strengthen that law, that we'll probably see a refinement. As kind of as I wrap up, as kind of a summary, as far as my own learning is concerned, I think the 14th Amendment and subsequently the Civil Rights and the Americans with Disabilities Act are key to understanding simple language. Title II, public accommodations. Do we fit that? With the Civil Rights, public accommodations, Title III of the Americans with Disabilities Act. Are we one of those organizations, or are we one of those entities? And I think those resonate, and I think those are really good laws to follow, and I'm glad that we have the structure. But as far as like saliency, besides Helen Keller, I think the Rehabilitation Act is one of those really, I think, well, for me, it was less commonly known. It wasn't on the radar, but I think it's one of those really key players in federal law that doesn't get mentioned enough. Section 504 of the Rehabilitation Act introduced civil rights and non-discrimination clause for people with disabilities. And even though there was this Rehabilitation Act 1973, there were still sit-ins, protests in 1977, and I think San Francisco, because the law wasn't being adhered to, right? So the law is established by people who want them, and then they're created, and then it requires the people to, in a very scientific manner, circle back and ensure that those laws are being applied and adhered to. On one of my final slides, I don't really like, I like the tree pictures that I have. They're big and beautiful and majestic, but I also feel like they're kind of, let's say, in the early history, right? It's kind of there's a nostalgic feel to it, but it's not a super soft feel. And I like this picture. It's a abstract, colorful picture of an apple tree with people who are able to access the fruit of the apple tree. And I think the fruit is both opportunities, but also protections. In this picture, I don't know who is protecting the apple tree. I would assume that everybody here is protecting the apple tree. But I like this picture because I believe WCAG represents this picture, where WCAG is the standard, the Web Content Accessibility Guidelines established by the World Wide Web Consortium back in the 1990s are really the global framework on which Department of Justice applies the standard for adherence to the Americans with Disabilities Act. So I feel like even though in previous pictures there were groundskeepers, and I equated them to maybe the DOJ, or maybe they were, civil rights activists or something. But in this case, I feel like this is a much more organic picture of how like people of the grassroots are taking care of each other and ensuring that the laws like Americans with Disabilities and opportunities and protections are accessible to everyone, and can be reached and are in reaching distance, as opposed to out in the middle of a forest somewhere. So with that, I think it's 2:56, and I do have a couple of questions. I'll read them over. How do you see yourself or your role with the study of practice of accessibility? Kind of still, I'm a remediator for some of our content, so I'm still kind of growing. Are you an accessibility liaison, a creator, an activist, a proponent? After April 26th deadline of compliance for universities, what might be some obstacles that your department, or other schools might face. And then the final question is accessibility missing anything? Are we missing anything that we would like to know about accessibility or that accessibility should include? So thank you for your time and your attendance here. I really appreciate that you're bending your ear for an hour and kind of getting some of the stuff manifest out in the open. Um, so let's see. We'll just leave it on the questions. Anything that sparked your interest, or even anything that I error in anything that I said, because this would be a great opportunity to learn. Because I still am a work in progress.
I just want to say thank you so much. This was very informative. And I love your passion.
Oh, I appreciate that. Thank you so much for saying that. Um, I think um, I think, talking about it and being excited about it, as opposed to saying this is what we need to do, is much nicer. It's a human touch, right? So thank you for your comment. Um,
There's some comments in the chat.
oh, okay.
Would
Let
you
me
like
see.
me to read them to you?
Would you do that? Would you read
Yeah,
some of them? I'd
no
appreciate that.
problem.
Oh,
Okay, so
thank you.
let's see, we've got a few of them. Let's see here. Renee says, this has been great. Thank you, Joseph. Just shared the
Oh,
note
thank you, Renee.
beg your pardon. It was from Renee
Oh,
Hinsey.
Brene, thank you, Brene. Yeah.
Yeah, they state that she states, just shared the note about capitalizing deaf and blind with the ASU writing community. AP style book corroborates, which is great.
Oh, that's a good thing. Oh, thank you.
Yeah, that's great. Karen
But
had
that
just,
would have been a learning process, and I would have appreciated it. So,
no, that's good.
um,
That's
okay,
good.
good.
Yeah, people are in and out, thanking you for the presentation.
Oh,
Uh,
that's nice of them.
let's hear, Kenna states, ASU is missing hands-on support for faculty to make courses accessible. I agree.
Mm.
Um,
Like
and
hands-on, like coming in person and like sitting down and working with and maybe showing on a big screen or something like that.
maybe that's
Yeah,
a really good idea. I mean, Kenna, do you want to discuss that in further detail if you're still here?
because that's a great suggestion. I
Yeah.
agree.
Hey, I'm still here and I need to hop off because I'm about to lead a meeting about latex and accessibility or LaTeX or however you pronounce that. I'm not a math person, but yeah, so we have our wonderful IDs. We have our amazing LX designers that provide hands-on support for faculty, but um, many of our units don't have in-house support. So this is something most of us have been advocating for years and years and years. And so I was just responding to one of your questions, Dr. Axel, that's I think our primary need right now is more hands-on support for this.
More. Oh, I like it. Thank you, Kenneth, for that. And that's what I kind of thought. That was a hypothesis. That was, what are other departments going through? And I know in our department, Global Launch, accessibility came on the radar maybe a few years ago, but more so in the past couple of years, and then really in the past like 4 or 5 months. So just like I go from knowing nothing about it to knowing something to knowing a little bit more, that I just anticipate that would be kind of the situation that everybody else is in. Um, so okay,
Yeah,
yeah.
every college and unit is handling it differently, and everyone has different types of support. I'm leading the effort for the College of Liberal Arts and Sciences, which has 18 schools, and only 4 of those have IDs. Of course, Ed Plus, their IDs are helping with this effort too, but we just have, so many courses that we can't possibly touch. But as Kathy says, we eat an elephant one bite at a time. So I gotta hop off, but thank you so much. Bye, everyone.
Thank you, Kenna.
Thank you, Kenna. Okay, there's other comments. Oh, Arena states, thank you. Your talk made me think about my responsibility as an instructional designer to seek consultations
Good.
from experts beyond
Oh,
technology when evaluating online courses and include all layers to achieve better results when implementing accessibility. Thank you, Arita, for that
oh,
comment.
Rena, yes. I think one of the first things you said was something about collaboration, right? Working with other professionals, bouncing ideas off, learning from them. I think that's so important. I think that's really grassroots in its nature, right? Like, let's come together, let's learn more about it so we could teach others about it as well.
Agreed, agreed. Other comments, they're loving your talk. Let's see here. Zoe states, this was very interesting. I would say I am a liaison and some obstacles I would do and do face is fully understanding how to describe the issue and how to resolve issues across different technical level teams.
Mhm. Troubleshooting, yes. I think in um, every discipline, troubleshooting is how do you take on a problem that's not described in the textbooks and then overcoming them. I think that's great. I think um, as I'm remediating, our own curriculum, I'm coming across issues with tables and pie charts and color contrasting, all that kind of stuff. And I think it'd be great if we had just a super extensive database of examples of what does it look like and maybe 30-second videos or something like that. Yes, thank
That
you for that comment.
that would be a great idea. I would love to be part of that. Han says, liaison from the graduate college. Biggest obstacle is knowing if I should spend time correcting errors on our website or creating accessibility tips for staff that they will be able to digest, or wait until larger ASU entities disseminate accessibility training.
Oh, that's a great question. Um, Boy, with this, I think easily digestible information to faculty members. I think to like a mixed methods, mediate and teach others how to do it. Like I taught English and psychology at Le Cordon Bleu for a number of years, so I've got a lot of food analogies, not allergies, but analogies. And I think there's a tremendous amount of value in teaching our faculty how to create accessible documents because accessibility goes a step beyond into the world of universal design, which is kind of this utopic design for um, for content so that anybody has access to it. Um, and so I don't know. I think you could do a needs analysis with your department and gather support and see who has an interest in it. I think that's a big part of in our department, how we are sharing accessibility. Colleagues of mine and I have come to Kathy Marks's accessibility meetings and have presented on little bitty baby step topics like how to hyperlink or how to add headings to how to use the accessibility ally checker, like really small things, not like the whole. Because if you go, here's WCAG, you've got like thousands of little criterion, right? Little individual criteria. Um, and so that's a good question. What do you do? Do you get a mediator? Like I'm using two accessibility tools right now, like Grackle and Inkable Docs, in order to provide a biangulation for the accessibility remediation that I'm doing. So I'm not trusting either one of them individually. Um, but I'm going through and doing it in a human way first and then checking. And they actually got in a debate with each other where they were making corrections on each other's remediations. I thought it was kind of interesting. Like Greco gave me a 22 out of 22, and then Inkable Docs rejected it, made corrections, and then Grackle rejected those, and eventually they came into agreement or alignment. But maybe a mixed methods.
Okay, okay. Well, thank you. I forgot to ask Renee, you did make a comment earlier and I did read it out loud, but I did not ask you to speak up if you wanted to speak up and elaborate on your comment. I apologize. Would you like to talk about your comment?
No, I just really appreciate, I co-lead the ASU writing community with my colleague, and we're constantly looking at language, the appropriate way to refer to different groups and to be respectful. So I really appreciated that tip as well as the whole
Great.
presentation in general.
Oh, thank you so much. I appreciate that.
Yeah.
Um, when it comes to language, like I'm a linguist and neurodivergent, so I have hyper focuses and I really get into like nuances of things. But when it comes to like capitalizing words, um, you really speak volumes. It's proper noun versus a regular noun, and I think I like the term uh, deaf-blind in that format because it really encapsulates Helen Keller, a quintessential example of a liaison of a person with insider membership to two groups who continue to be an advocate. So, sometimes when you look at APA, there might not be an example, but I think I went to the sources like American Federation for the Blind and other sources to triangulate the correctness of that. But you could argue linguistically why it's proper. So thank you for that comment. I appreciate that, Renee.
Yeah, no worries. Yeah, I find that we're constantly evolving the ASU writing style and trying to, chalk up to everything the charter wants us to be. So for sure, yeah, we need to keep looking at that stuff.
Yes, and that's what the law is. Keep looking at it's a revisiting. It's a amelioration, making better of something and fine tuning it. And I think that's a great way to conceptualize WCAG and ADA that it's like the California San Francisco mother dough for the sourdough, where it's been around for like 150 years, and you take one little piece and you make more, and it's an evolution. It's an organic living thing, and I think being adaptable to change, I think, is probably one of the most skill sets that we could have as an institution. Just adapting and accommodating and continue being accessibility liaisons and talking to people about it.
Are there any other questions from the group?
I just really enjoyed this. Thank you very much.
Oh, thank you, Kathy. Like
Thank you.
I'm your mentor. You are the guru, and I just really appreciate you like teaching me about this totally different world. Um,
It is.
like WCAG was a total mystery to me, and in your format, Kathy, as a leader, as a mentor in the accessibility group, because you started the accessibility liaisons group, I believe, in 2022, and you have just introduced me and my colleagues to lots of different wonderful ideas in a totally different world. And your demeanor and your welcoming approach have, you might not think it, but I have some social anxieties. So to be welcomed into a group like you do really helps with that,
Thank
bringing
you.
people on board into,
I'm glad.
a movement, right?
It
So
is.
I appreciate you.
Because I think, we are changing this group, especially we're changing the culture. Um,
Yeah. Yes. Instead of like maybe an esoteric culture that we're bringing everybody into the fold,
yeah,
right? Where only we have this specialization and we know about this. And I don't think it's going to be that way. I think everybody will just do accessible things in the future because that'll be the norm, in my opinion. I think that's the way it's going. I mean, there will be people outside of that don't conform, but like everybody around the world and, all the global corporations and institutions and government entities and schools that apply the WCAG standards do so for a reason,
Yep.
or reasons. So, yes.
I mean, I do think that, being on the technical side, working with ET, I think of accessibility as a technical problem, and we can have technical solutions for it, whether that's
Mhm.
going to be AI or whatever. But that only, I mean, yes, this is true. I mean, we will be able to lead people to being more accessible, but there's always going to be that human aspect,
Mhm.
you wanting to do the right thing. So thank you so
I agree.
much.
Yes, thank you too.
Great.
Thank you for giving me the opportunity. I came into, I don't know if I said this at the beginning, but I participated in a universal design for accessible technology working group
Mm.
with Alejandra. I think it was last week even, wasn't it?
Yeah, we
And
were
I
at
said, what?
UDAC. We were at
Yes.
UDAC.
And I appreciate you entertaining me, being a new member of that group. And I'm like, hey, what do you think about this presentation? Because it had been kind of stewing in my brain. I thought, well, if I offered to talk about it, then I would learn so much more about it. And so I think that would be a quid pro quo all the way. So thank you, Alejandra.
That's fabulous.
Of course.
Yeah, if anybody, UDAT is the Universal Design and Accessible Technology Group. That's a mouthful. But it deals a lot with academics, so making online courses accessible. And it really is a working group. So they're actually making tools, making courses in that group.
Mm,
So yeah, anybody who wants to join that,
interesting.
yeah, look on the accessibility site. I think the meetings are advertised there. So yeah, it's a good group.
Thank you for that.
And I think with that, we're going to conclude our presentation today. I want to thank you, Dr. Axel, for coming to speak with us about the historical and legal roots of web accessibility. It was a wonderful conversation. I really enjoyed this talk. It was so rich. I mean, it was just so wonderful. Thank you so much for coming to speak.